Welcome to Adding Value with Assar, the show where we dive into the stories, strategies, and market insights shaping the world of industrial and logistics real estate. In each episode, we sit down with industry leaders, investors, developers, and tenants to explore their journeys, unpack current market trends, and share takeaways that can help you better understand and navigate the business. You guys can work through this, right? Like you can
screw up all you want. You can screw up all you want. You're doing real well on this to start. So I see things being positive going in.
Well, it means good news for all of us.
I hope so.
Yeah.
If not, you can roll back the tape and yell.
Yeah, that's right.
I would say a common trait and something for young people or new people in the industry to think about for successful brokers is the ability to listen.
Value creation is not just about the numbers and the financial stuff. It's about creating value for our customer.
I remind myself, like, this is the business we got into. This is what we got into.
Yeah.
The prerequisite was that you just don't give up.
We having the Kelsey brothers on next time?
Maybe, who knows? A quick note for our listeners. If you're an owner, asset manager, or leasing manager with a 100,000 plus square foot building in vacancy coming up in the next 18 months, I'd love to talk. A lot of assets in this market have been represented by the same legacy brokers for years. Sometimes that works, and sometimes it doesn't. If you're ready for a fresh, aggressive approach to reposition and market your property, please contact us. I'm Assar with Voight Real Estate Services, and let's add value to your portfolio. I'm pleased to welcome Andy Prochnow, a seasoned commercial real estate attorney who specializes in contracts for leases, purchase agreements, ownership operating agreements, LP sponsor structures, and the full spectrum of due diligence work during escrow for buyers, sellers, landlords, and tenants. Andy's insights into the legal side of the commercial real estate are especially valuable for property owners, developers, brokers, and investors who want to understand how the deal documents really work behind the scenes. Welcome to the show. Well, Andy, thank you for joining the show today.
Thanks for having me.
Yeah, when I think about our friendship and our working relationship, I look back on kind of when we met, how we met, and I'm going to wind back the clock about, I think it was 5 years ago. And I was doing quite a bit of door knocking, and I was looking for essentially buildings to sell. And I came across a building owner in Jurupa Valley. He owned a 60,000 square foot building with 2 units in there. He was occupying one of them. And for on and off for a couple years, he was considering selling. And then finally, when the opportunity presented itself to sell, he wanted to sell off market. And I don't know why, but he was looking at offers off market. And I came in I represented a buyer, Brookfield. And when he received the offer, he said, I want you to deal with my attorney. Just call Andy. And that's how we originally met. And you essentially brokered the deal for him, represented him. You ran a process because I think there were multiple buyers at the table.
There were. We gave you guys a best and final demand.
You got a best and final demand. It was a small process that was ran, and we were fortunate enough to be selected. And we went into escrow, and Brookfield brought in their counsel. And it was a successful deal, both for the buyer and for the seller as well.
Yeah.
What I remember the most is that, I remember that even though I'd never heard of you, Brookfield was represented by Cox Castle. And
heavy hitters.
Big real estate law firm. And not only did you handle yourself in a very professional manner in that process, but you held your own weight. I mean, I looked at it afterwards and I said, this guy is sharp. He can duke it out with the best of them and get the job done. And I grew a lot of respect for you, and we started dialoguing afterwards. 5 years later, we have a great working relationship, and you do a lot of business. We refer a lot of business to our clients because we trust you, and you do a great job. So thank you for coming on the show. For folks who may not know a little bit about your background, can you tell us a little about you, the type of real estate law that you practice? Please do.
Sure. Well, thanks, and I appreciate the introduction. So I'm a commercial real estate attorney. I've been practicing here in California since 2008. I represent buyers, sellers, landlords, and tenants in all facets of commercial retail and industrial real estate. On the development side, I take dirt and work with clients on developing vertical, leasing up the property, and ultimately selling it off if that's the intent.
Mm-hmm.
On the landlord side, we deal with operations, management, leasing. Likewise on the tenant side, when people are looking for properties, scouting properties, negotiating their leases, we dive in and we help negotiate the details, because that's really what the parties have to rely on over the course of a relationship.
Sure.
And then from there, people looking to get into real estate, whether it's their first time in buying a single asset, whether it's industrial or retail, or if they're buying something bigger, say a larger development, shopping center, or a big industrial park, we'll dive in with them and look at all of the due diligence and make sure that it's the right fit, it's billed as advertised. And then from there, it's managing the relationship when things come up in property ownership and management. And so we are a resource to our clients whenever they have a legal issue. And if it's not something we can handle, then we can point them in the direction that they'll need to go to find someone who can help them.
So if I hear you correctly, like you essentially cover the whole spectrum, right? If we're talking a client needs help with a lease contract, a purchase agreement, operating agreements, JV agreements, anything real estate related and contract related, you can advise on.
Yeah, there are some things that we don't dive particularly deep on, say your syndications, your private placements. We will do some light work on that, but I generally will refer that out to people who specialize in that. But as far as real estate is concerned in general, yes, your operating agreements for your operating entities, your investor entities, and then all of the real estate documentation, your purchase and sale agreements, your leases, your CC&Rs, financing. We work with a lot of clients who are doing either an acquisition loan or a refinance loan or a construction loan. We'll work with them and the lenders to make sure that they get to the finish line.
It's interesting because sometimes, we were just talking about this while we're in the business, we sometimes forget how much we know, right? And one of the most common questions we received from private owners is, what is the difference between a triple net and an industrial gross versus an industrial gross or a gross lease? High level, if you were to break it down for someone to understand, what would you say it is?
Well, a triple net lease passes through the operating expenses of the property, your insurance, your taxes, your common area expenses, association dues. They pass all that through to the tenant. So the tenant might have a lower base rent, but then there's a variable component to that depending on what all of these other costs are.
Variable is a key word, right? Because it can change.
Exactly. It can change year over year depending on market conditions, depending on tax reassessments. Sometimes landlords sell their assets. And as you know, here in California, that triggers a reassessment.
Mm-hmm.
So your property tax might be X one year. If the landlord sells and those property taxes get passed through to the tenant, well, the year after that, they're going to go up, and they're going to go up to whatever fair market is. So depending on the hold period that the prior landlord had, if they own the property for 10, 15 years, their property tax basis is pretty low.
Mm-hmm.
That's going to get hiked up significantly. So the tenant really has to be aware of what these costs are. They have to look at it and they have to factor that into their budget. Because if they're not looking at that and they're just looking at the singular base rent number, that's not an accurate depiction of what they're really going to come out of pocket every month.
Right.
For a landlord, a triple net lease is great. It provides a consistent NOI, and it's essentially a hedge against inflation.
Mm-hmm.
They're passing through all of these costs to the tenant.
It sounds like it's a conversation about risk, right?
Oh, absolutely. Absolutely.
On a gross lease, the risk of inflation or certain costs rising moves onto the landlord side.
Correct.
In a triple net lease, all that risk and maintenance in addition to that moves on to the tenant side.
That's exactly right. And with a gross lease, the landlord is basically betting that they're going to be able to handle whatever improvements or maintenance, insurance, and taxes on the property in a better fashion than what inflation would otherwise bring.
Mm-hmm.
And so it's more of a fixed number to the tenant. The tenants are going to love a gross lease. You just aren't seeing a lot of them anymore in the industrial and retail space.
Why do you think that is?
The landlords want predictability, and they don't want to hassle with the day-to-day costs. They want the tenants to handle and maintain their property for them. You're also seeing that with a lot of landlords, especially the institutional landlords, these are portfolio assets. So they want their properties maintained a certain way, and they want them, they want all of these costs passed through to the tenant, because that's going to affect ultimately what they're paying their shareholders and investors.
I've noticed in a couple leases, I've noticed tenants complain in the past, especially on the triple net leases, that to your point about the unpredictability, sometimes it's misrepresented what the estimated operating expenses are. And there's not a lot of protection in the leases for the tenant to kind of cap that, right? So in other words, it's presented before they sign a lease that they're estimated to be 25 cents a square foot. But then after they take occupancy, and there's nowhere in the lease that actually depicts that, and then after they take occupancy, it actually ends up being 30 cents a square foot, year one. Have you seen that before?
Oh, you see it all the time. I think one of the things that you try to distinguish whenever you're looking at a lease, especially if you're tenant counsel, you branch out your operating costs in both controllable and uncontrollable operating costs. Your uncontrollable operating costs are those things that they're going to change no matter what, and the landlord's going to expect you to pay them. That'd be your insurance premiums and your taxes for the most part.
Mm-hmm.
Then there's everything that's controllable. That's more your day-to-day maintenance of the property, the things that the landlord can actually have some form of control over how much is going to get passed through. And so what you may see is a landlord agree to potentially cap a year-over-year on controllable expenses, but not cap the uncontrollable expenses.
Mm-hmm.
If you can get your landlord to agree to a cap on everything, hey, you're doing something right.
Right.
But most landlords are savvy enough to stop you on your tracks there and say, well, maybe we'll think about it here, but we're not going to do it with the non-controllable expenses.
A quick note for our listeners. If you're an owner, asset manager, or leasing manager with a 100,000 plus square foot building in vacancy coming up in the next 18 months, I'd love to talk. A lot of assets in this market have been represented by the same legacy brokers for years. Sometimes that works, and sometimes it doesn't. If you're ready for a fresh, aggressive approach to reposition and market your property, please contact us. I'm Shai Assar with Voight Real Estate Services, and let's add value to your portfolio. I think what happens with the landlords is they know that other landlords probably won't agree, so it's almost like this front line that everybody keeps, and they're hoping that nobody ends up giving, especially as the deals get larger.
Yeah.
Right? I mean, I think when you look at our market, I'd say deals under 100,000 feet, definitely if you're dealing with a private owner. Now, the institutions it feels like 90% of the time are going to be doing a triple net lease.
Yeah.
No matter what size the deal size is. But definitely with private owners, there's a little bit more flexibility to do an industrial gross lease. But anything outside of that scope, I'm working with a tenant right now who's really looking to cap the property taxes in the event of a sale. And they want to lease about a 200,000 square foot warehouse in the West. We had offers out on a number of institutions, and I just kept telling him, I was like, this is just a no-fly zone. This is not going to happen. Nobody's going to agree to it. We also were trading paper with a private owner who owns a bigger building. And I was actually kind of hopeful that he might agree to property tax increase protection. Having said that, he was savvy enough to know that nobody else would agree to it either.
Yeah.
So he refused to do so.
That's your good old Prop 13 protections. We used to see those a lot more in agreements, and pretty much everybody's wised up to, if you're a seller or a landlord, you're not going to agree to Prop 13 protections anymore. And if you do, which is rare, you'll usually see it limited to one sale over a certain period of time, and anything after that, then maybe they'll kick in a protection. But
and the reason that's important is for those just to kind of understand a little bit is if a property were to sell, right? And let's say, and we're going to talk on per square foot, the property taxes go up 10 cents a square foot.
Yeah.
If it's capped, then it comes out of the base rent. So in theory, the landlord is collecting less rent. The new landlord is collecting less rent on a transfer of the property, which in turn means he has to pay less when he wants to buy it. And that's why it's such a sticky subject, because if there's no Prop 13 protection, then the 10 cents increase in property taxes, well, the new landlord's just going to get the rent that he's going to get.
Right.
And that 10 cents is going to get passed through to the tenant.
And that's going to affect the marketability of the property.
Exactly. And that can translate, like 10 cents on you put it on a cap rate, can translate to a lot of money on a sale.
And lenders are going to look at that too in terms of what the cash flow is. So that's going to affect, in lending terms, what your loan to value is based on the rent that's coming in. It's a tough topic to negotiate, and unfortunately, most tenants nowadays are just stuck with the bill.
Mm-hmm. Maybe a little bit out of your expertise, but I'm just assuming because you probably see a lot of deals over the course of the last 2 years. What have you seen been happening with insurance in the state of California?
Insurance is a tough one, especially with all the institutional landlords that are coming in. Your big REITs. They require a lot of insurance, and insurance premiums in California, especially with the wildfires and other hazards that we have here, earthquakes, floods, insurance premiums have gone through the roof. And there are less insurers in the state now, which have driven up prices. That all gets passed through to the tenant. Mm-hmm. I've seen it where you have insurance premiums one year differ tremendously from what they are the following year, and you'll get a lot of tenants who are on triple net leases have some sticker shock at that. Mm-hmm. And unfortunately, the way that these leases are written, they're still on the hook for paying that. Mm-hmm. And so that's something that tenants really need to factor in when they're looking at where their property is, how old the building is, what the surrounding area looks like, just to get an idea on what the insurance risk is ultimately going to be. And then in turn, doing their due diligence and really inquiring with the landlord what insurance premiums look like when they have their renewals, who they're using as insurance providers, to the extent the landlord's going to divulge that information. Because again, this all factors in for a tenant how much they're coming out of pocket every month. Mm-hmm.
Especially as it continues to increase every year.
Absolutely. Now, a lot of institutional landlords too will have broader blanket policies, and sometimes, depending on the institution, they may be able to give you a more predictable number because they insure their entire portfolio, not a property by property specific policy. In which case, that does provide a little more predictability. But again, as conditions change, especially as we've seen here in California, premiums will continue to go up, and depending on how the institution holds their policies, that still is ultimately going to affect and get passed down to the tenant.
Have you seen when they have, say, portfolio insurance, does that translate into any benefit and cost savings to the tenant?
It can. It can, depending on how broad the portfolio is and what their coverage is. I've had a couple of recent deals where, for instance, here in California, as a tenant rep, I'm going to fight hard to make sure that flood and earthquake insurance aren't included because they're very costly premiums. And while in California, it's something that you always have to think about, it's not necessarily a requirement of a lender or bigger institutions unless you're really in a seismic zone or a 100-year floodplain. Mm-hmm. That said, a lot of the institutions still bundle these policies in with their broad portfolio. To the extent that they're bundled in and already accounted for, the cost becomes a little lower as opposed to if they were taken out on a specific property just for that property.
Let's talk a little bit about AIR leases. And I think this is a great subject because, I'm obviously not an attorney, right? And an AIR lease is pretty widely used as a standard for most private owners and some institutions in our marketplace. And especially when I speak with, because one thing that I highly encourage, because I'm personally a believer, any client that I work with or represent, I highly encourage them. We can give our business comments, we can speak to experience, but I always highly encourage them to engage with counsel, a commercial real estate attorney. And sometimes the feedback I get is, well, we're just going to use an AIR lease. That's a pretty standard lease. It benefits both sides pretty equally. It's fair. I don't really see why I should use an attorney. What is your opinion? I mean, obviously, we don't have the legal opinion, but, just what are your thoughts on that?
Famous last words.
Yeah.
Right? Well, the AIR agreements, the purchase agreement and the leases, they're broker-driven forms, as you know. They're meant to be a one-size-fits-all for a deal, but they have their place in the industry. Now, as an attorney, I'm not a huge fan of these agreements because they're hard to customize. But it doesn't mean that there aren't deals where they work. When you've got an easy deal between private parties, and there's not a lot of changes to the deal parameters. There's not you're not dealing with outside the box things like tenant improvement allowances or potentially quirky insurance arrangements. The AIR can work. When you do get attorneys involved, we all have our own addenda that we're going to throw on there to change certain provisions because we know how they ultimately will come out in the wash if they're litigated. But the AR agreement gets you to the finish line pretty quickly. So for those certain deals that are quick and easy, yeah, it makes sense. That said, attorneys want to have their fingers in the pie.
Sure.
They want to advocate for their client more than what the AIR does, depending on the side that they're representing. And so it's kind of a balance between what was negotiated in the LOI, what does the property look like, what are the needs and demands of the tenant with respect to the space that's going to be leased, and what is the landlord looking for in terms of the tenant arrangement. And that's really a judgment call. I have a lot of agreements that come from brokers like you that are on the AIR form. It doesn't scare me, but at the same time, you have to read the agreement, even though you've seen the agreement 100 times, because every deal is different.
Mm-hmm.
And so it's not, even though it's marketed as a one-size-fits-all, it's rarely the case.
Mm-hmm.
And as long as you have somebody looking over it and making sure that there are certain provisions that are taken out if they're not applicable, or if there is a particular element of the deal that's not addressed in the AIR, that it is referenced somewhere, that's really what you want somebody looking at.
Mm-hmm.
And that's really where the attorneys are going to come in to assist.
For sure. I mean, we were just working on a lease the other day. A couple guys, obviously a team of guys we work with, and we were drafting a lease, and there was a little bit of the deal that spoke to tenant improvements, but to your point, kind of the unique parameters of the deal.
Mm-hmm.
And one of our teammates, because it's instinctual, because a lot of brokers have kind of worked it this way, and they maybe just look at it that this is the way you go about it. They start writing their own paragraphs. Tenant improvements should be done like this. They should be done like that. Has to be approved by landlord, by code, this and that. And then I looked over it before we send it out, and I was like, no, we're not playing attorney here.
Yeah.
And I hope that when we turn to our clients and we say that we're not playing attorney here, it's not because we're being lazy, right? It's really because, like, if something were to go wrong,
Mm-hmm.
it can go wrong very poorly, and it'll reflect badly on us. And so we have to encourage our clients to engage with counsel like yourself, that if they do need to put some unique parameters on the deal, that it has to be done with an attorney that represents their interest.
And, the attorney that you choose to do that is very important, because some attorneys understand that the deal doesn't need to be over-legaled.
Sure.
And as you put, you have to translate brokerese into legalese sometimes so that it fits the particular item in the lease that's trying to be addressed.
Mm-hmm.
But it doesn't mean you need to turn a paragraph into 3 pages.
Sure.
And that's really where the utility of the attorney comes along, to recognize what needs to be done, how can it be done as invasively as possible, but at the same time protecting the client's interests.
Sure.
Because at the end of the day, the attorney works for the client, they advocate for the client, and the idea is to get that done without taking 30 days and 4 or 5 back and forth red lines.
You have to be a deal maker.
Yeah.
You have to represent your client. You have to do your fiduciary, but at the same time, you have to be a deal maker, not a deal killer.
Yeah.
For lack of a better word. So on the topic of leases and even purchase agreements, what would you say, because you essentially do both sides of the gambit, right?
Correct.
Working with both tenants and different institutions and landlords. What would you say the biggest difference is when you're working on an assignment or a contract with, for example, an AIR agreement versus a custom contract that may be done with a large institution? Other than the fact that one's probably 7 pages and the other one's probably 70 pages.
Right. Well, the AIR agreement is built for speed.
Mm-hmm.
depending on the side that I'm representing, if it's a lease or if it's a purchase and sale agreement, you have to identify what your client's interests are, but also understand that they're likely wanting to get this done a little more quickly. When you have the institutions involved, those agreements are pretty substantial because they're written by attorneys who understand from a litigation standpoint where you can get burned. And as a result, you really have to take time in negotiating the various provisions there. It might be the indemnities. There might be post-closing items in a purchase and sale. In a lease agreement, again, we get into what kind of triple net items are capped or what kind of triple net items are not going to be permitted. For instance, an example in the institutional leases, a lot of the big REITs come into California and they want to pass through all the new green energy improvements to their buildings onto the tenants. Well, when you do that, that can get quite expensive quite fast. Now, understandably, the REITs are trying to build a portfolio of assets that have a certain appeal and allure to them, and that they can turn around and market to their shareholders and say, well, we have all these buildings that are, LEED certified.
Sure.
But that comes at a cost, and in a true trip net, that cost is paid by the tenant.
Mm-hmm.
So you have to be careful to negotiate things like that.
Do you find that you have a lot of success negotiating these items with the institutions, or those are pretty hard no?
Sometimes. It really depends. It depends on the age of the building. It depends on the location of the building. And then ultimately, and this goes for any deal, it comes down to leverage.
Mm-hmm.
Every deal has leverage, and the amount of leverage you have depends on how much you push certain items.
Mm-hmm.
If you're a small tenant dealing with a very big and powerful landlord, you have to be very picky and choosy on what you're going to ultimately ask for, knowing that if you go and give them a laundry list of things, they'll probably turn around and say, maybe this isn't a right fit.
Mm-hmm.
So everything really is a balancing act, and understanding where that balance hinges on is how you get a deal done or how you break a deal.
Shifting to, we're in the fourth quarter of 2025.
Mm-hmm.
You have a pretty diverse client base ranging from both industrial and retail, but maybe more specifically in the industrial side of the world. What type of transactions or assignments are coming your way?
Lately, I've seen more leasing than I have purchase and sales. There seems to be a bigger influx of industrial leasing, a lot in the Inland Empire, a lot of manufacturing and last mile shipping.
Mm-hmm.
That's been pretty popular. Now, again, how that ultimately is going to work out with the tariff situation, the last couple of years, I saw a lot of that happening. And then now you're seeing a lot of those businesses not doing quite as well.
Mm-hmm.
But I would say definitely on the industrial side, I'm seeing a lot more leasing than I am buying and selling.
Okay. And on the topic of buying and selling, one of the services you've provided, and it's been very beneficial for our clients that we've represented on buy assignments, is essentially you can kind of kick into gear not only negotiating the purchase and sale agreement on their behalf, which love to speak about kind of some things to look out for in an AIR purchase and sale agreement that'll be important, but then you can kind of see through the transaction with them during the due diligence process all the way to the close.
Right.
Taking it from the purchase and sale agreement, what would you say or be some things for a buyer to look at and consider if they're going to be buying an industrial building?
Well, I mean, the big thing that anybody wants to look at when you're buying industrial property is, what does environmental look like? And you're going to find that out in the due diligence phase. But as a buyer, you want to have or get from the seller as many reps and warranties as you can, because those are your warm fuzzies. That's what at least lets you know what the seller knows about the deal.
And in an AIR, is it 2 years or 3 years?
AIR is a standard 2 years, I believe, which is honestly outside of market. Normally, a sophisticated seller is going to give you maybe 6 months to a year.
Mm-hmm.
A lot of people don't catch that in the AIR.
And what you mean by reps and warranties means that if you buy a property and something was not represented to you or represented incorrectly to you, after you close escrow, there is a period of time that you have warranty to go back to that seller and say, hey, this right here was not correct, and for that reason, I'm owed damages, right? Is that a fair statement?
In theory, but then there's lots of shades of gray there, because a sophisticated seller is going to potentially cap what you could ultimately come after them at.
Is that in the liquidated damages provision?
No, that would be a custom draft provision.
Got it.
So if you're a seller, you're going to want to limit how much a buyer could potentially come after you outside of, fraud or willful misrepresentation, which I'll be honest, in the 15 years I've been practicing, I haven't come across yet. Knock on wood. That said, your representations and warranties, they help put the buyer at least in the same position that the seller's in with respect to actual knowledge about the property. Now, it doesn't always work out that way because a lot of times you have what are called absentee sellers.
Mm-hmm.
They're people who aren't directly involved with the day-to-day of the property. So, Shai, if you were to tell me, well, I'll give you, an actual knowledge rep with respect to certain conditions at the property, that's great and all, but if you're an absentee seller, that might not really move the ball forward very far.
Mm-hmm.
In which case, then the emphasis really becomes on the due diligence aspect of a deal. As an attorney, it's my job to stress test the deal. I go in looking for a problem.
Right.
And I look at everything from existing leases. I look at title. I look at third-party reports to the extent the client is going to engage certain contractors, surveyors, soils reports, environmental reports, zoning reports, natural hazard disclosure forms. And I determine whether or not there's something there that could materially impact the buyer when they take title to the property, and see whether or not they're really buying into a potential litigation.
Mm-hmm.
And believe it or not, there's a lot of deals that are marketed as clean, easy deals, and then you open up the proverbial hood, and there's a mess there. Now, there's often a solution to the mess, but it takes a little more creativity and a little more involvement of the parties. But you just never know.
Mm-hmm.
I've seen the cleanest deals on paper turn out to be nightmares, and I've seen deals that are, $50+ million that you would think, oh, this is going to be a heavy lift. And they're some of the easiest deals I've ever done.
Sure. Can you speak to maybe an example of a deal in which everything looked as if it was going to be okay, but then once you kind of sort of lifted the hood and take a look at everything, you were able to find some challenges in there, and how you were able to maybe overcome those challenges in the deal?
Sure. Well, I've actually got a current one I'm working on right now. It's a commercial property.
Great, love it.
Yeah.
Yeah, let's talk deals.
Yeah, we've got our sleeves rolled up on this one, but it's a property where you've got a tenant with a lease that's not recognizing or subordinate to existing CC&Rs.
Mm-hmm.
And you also have easement rights where another unrelated party in an adjacent parcel has a right to put a pylon sign on this tenant's property.
Mm-hmm.
And yet the lease doesn't recognize that there's this other easement out there and that somebody might put a pylon sign right out front their door.
So you're saying that there was a lease that was signed between the landlord and the tenant,
Mm-hmm.
and then the neighbor has rights to that tenant's property.
But the lease doesn't recognize those rights.
Okay.
So you've got an issue there as to whether or not, is that going to create an issue between the landlord and tenant?
The new landlord, the new owner and the neighbor, right? In theory, because you're representing the new owner.
Because you might have a quiet enjoyment issue there.
Oh, I see.
And then on top of that, you've got a set of CC&Rs for an undeveloped portion of a center that obligate the tenant to do certain things, but the lease doesn't obligate the tenant
To do that.
to do those things under the CC&Rs. So we've got about 4 different unrelated parties all involved now, and it's an interesting one.
Yeah, because how do you get everybody to come to the table, right, to change things around? I think the responsibility would, in theory, be on the seller, right? Because it's his responsibility, his or her responsibility.
Ultimately, that's the seller's mess that has to get cleaned up. A good seller is going to recognize that, because even if my client, who's the buyer in this particular instance, walks away, the mess isn't going to leave. It's still going to be there for the seller and for any other potential buyer down the road.
Mm-hmm.
So it's something that has to get worked out, and it's something that ultimately, maybe money needs to change hands. There's in this particular deal, there's a couple of different areas where there's some hidden leverage,
Mm-hmm.
and so you have to push that where you can. But it's a delicate situation because you're dealing with parties who don't always have to entertain your offer.
Sure. What would you say the biggest difference is working with both private owners and tenants and maybe larger institutions and corporate companies?
Sure. Well, the private owners are generally easier to work with. You have deals that are more negotiable, and ultimately they're very focused on getting it to the finish line. And so you may have a more aggressive initial starting point, and then ultimately everybody's going to cave on certain issues, or the dust is going to more or less fall in the middle.
To cut a deal.
Yeah, because that people want to get the deal done. They want to move on.
Yep.
Again, I say that with the qualification that you still have to protect your interests as best you can, and nobody's going to do a deal that has too much risk involved. But there are judgment calls and risk evaluations along the way. I might tell a client, hey, you do have exposure here, but your exposure here is very low. It's a business decision, but you're probably going to be okay.
Yep.
Ultimately, they pull the trigger, not me. In your institutional deals, the institutional parties really don't give a lot. And that's because they come from a very consistent and reliable point where what you're getting from them is transparent. Their deal has been tested. They've bought into that deal previously or developed that deal, and they do it with a certain level of sophistication where there's not a lot hidden, but at the same time, it's one of those where if you're trying to get them to push that far off their form, they're probably going to tell you it's not going to happen. So the devil's going to be in the details of the due diligence documents, what the numbers really say. And then from there, really testing how the deal works for the client if you're the buyer. If you're the seller with the institutional clients, you might have a little more control because they may push their form on you, but again, they want your property. So sellers are going to have a little more play to, get certain things like release and indemnity agreements and, limitation on post-closing liabilities, that sort of thing.
You have your own custom contracts, right? So, for majority of transactions, if you can have, to your earlier point, you had the leverage in the deal to use your own forms, you use your own forms.
Yeah, the saying in the industry is he who controls the form controls the deal. So if given the option, I'll take the form, I'll draft the contract, because then I'm playing with my own language. I know where I can back out from my own language, where my settlement positions are with respect to certain terms. When I'm dealing with someone else's form, I have to insert all of my own provisions in there, and that can be a task. It really depends. I've seen some forms that look like they're simple, but when you get a 10-page purchase and sale agreement, it's not going to have a lot of stuff in there. And so you've got to add a lot. I've seen some that are 60 pages long, and those can be a nightmare.
Sure.
And so it's really finding that balance. When you're not working with your form, you have to be delicate. You don't want to go in and just completely remove a paragraph and put in your own paragraph. You have to work with the other person's language. And so that's really where the creativity and the custom drafting comes in.
A piece of this is because we, as brokers, we come across a variety of type of deals, right? And just because we see so much velocity, we can firsthand appreciate a lot of things in the business, but certainly appreciate, a good real estate attorney's involvement in a transaction. And unfortunately, sometimes we find that working with clients, a lot of times, just because they may do one deal every few years, or it might be the first deal they've done in a decade, they may not either know or kind of appreciate the value of a good real estate attorney can bring to them as far as counsel in any agreement. What is your kind of thought on that and kind of bringing a deal all together with a good team?
Well, in real estate, you need to have a good team that generally comprises a knowledgeable broker, a good attorney, and a good CPA, because that's going to help you evaluate any kind of deal. The attorney comes in, and if they're seasoned, if they know what they're doing, and they're of a relationship mentality, as I am, they're not just in it for the deal, and then once the deal closes, they disappear. They're a part of your team, and they continue to be a part of your team in helping you evaluate ongoing needs. I have plenty of clients who do deals sporadically every couple of years, or I might not hear from them for 5 or 6 years, and then they pop up out of the woodwork. That's okay, because you're still familiar with the client. They're familiar and they're comfortable with you and your level of expertise, and they know that even if it's a small task, you're going to give them sound and honest advice without racking up a huge bill on them.
Sure.
I know there's a lot of sensitivity out there to legal billings, and there's plenty of people who've been burned before by attorneys that just have, 8 or 9 page invoices with hundreds of line items on there for email here, telephone call here. Legal bills aren't glamorous. Nobody wants to pay a legal bill the same way nobody wants to pay a car mechanic bill.
Yeah. Or brokerage fees. Yeah.
But, it's a necessary evil in our business. And, I can say, as far as the attorneys involved, we provide a certain level of insurance on telling you what your deal actually says. Surprisingly, a lot of people don't read the agreements they sign.
Mm-hmm.
And somebody needs to read it, and somebody needs to advise you on what's really in there and what your potential exposure is.
Sure.
So that if and when that situation arises, you have knowledge of it.
Yeah, absolutely. And I think you bring up a great point, and I think it's important to highlight that not only should a property owner, when they're going into a transaction, have a great real estate attorney, having a great attorney, but it has to be a specialized attorney, a commercial real estate attorney. Because I have to be honest, we do come across cases where owner has a relationship with somebody who maybe practices business law, really not very, maybe seen some real estate stuff, but also does personal injury and employment disputes and things of that nature. And anytime one of those attorneys, I don't want to talk bad about attorneys, but when they get inserted into a deal, we just know it's going to be a wild card.
Yeah.
We just know that we have no idea what direction this deal is going to go. We're going to end up fighting and negotiating over items that are non-issues and completely overlooking items that are the real components of a deal.
Yeah, it's the Swiss Army knife attorney.
Yeah.
Yeah, those deals, I've come across a few of those, and they're tougher because the other attorney may not have the full understanding of the concepts that we address, or they may not know realistically where the settlement position is on a lot of things. Everybody postures at the beginning of a deal, but ultimately knows where things are going to ultimately settle to get the deal to the finish line. You kind of have to take these specific circumstances with these attorneys on a case-by-case basis.
Yeah.
And, I'm a big fan of just picking up the phone and calling and having a conversation. Don't hide behind your email. Really be present in the transaction, because that's really what gets people to understand positions. You can send emails all day back and forth with what your reasoning is or your justification, or just hide behind a red line. But it's the attorneys who talk and reason with each other, again, with their client's involvement, with the broker's involvement, and getting everybody on the same page to ultimately get the deal done.
Mm-hmm. It's the same reason that if somebody were to call me and say, hey, I have an assignment and it's maybe land for commercial real estate development in the Bay Area, that I might be a real estate broker, but that is just way out of my scope of expertise.
Right.
You're just better off referring that to someone else.
Mm-hmm.
If owners, potential clients out there want to get a hold of you, maybe have a consultation with you, what is the best way to reach you?
Well, I'll give you my contact info to drop on the notes for this. But
for sure.
I practice here in Costa Mesa, California. A firm called Buckner Robinson Murkovich. Our phone number and our info, or you go ahead and put on the podcast.
Sure.
But I make myself pretty available to my clients, so that when you need to get a hold of your attorney, you can get a hold of us. We're pretty responsive.
Now, I will say one of the best attributes of working with you is you're very prompt, and you recognize the urgency that comes with making a real estate deal.
Mm-hmm.
Now, I understand, obviously, you prioritize with your own potential other clients that you're working with, but I've never found myself to be frustrated with you not turning around an assignment in time. And so I would agree that that's a great quality to have.
Well, and understanding too, depending on what stage you are in a deal, some things deserve and require more prompt attention than others.
Sure.
But, just knowing that, hey, I saw your email, I can't get to it right now. but I recognize that you're in the queue.
Yeah.
And it's a juggling act. I mean, you see it in any industry. You've got multiple fires, and you're always shuffling something from the front burner to the back burner. It just depends on where the urgency really is, depending on the deal.
Yep. Well, I appreciate you coming on today. It was a lot of fun, and look forward to continuing our working relationship.
Absolutely.
Thanks,
man.
Shai.
It was a pleasure to be here.
Likewise. Cool. Thank you for listening to Adding Value with Shai Assar. We'll continue bringing on guests with stories and insights that matter in the world of industrial real estate. If you enjoyed today's episode, please share it with a friend or colleague. And if you're a landlord, tenant, or investor exploring opportunities in the Inland Empire, feel free to reach out to us. We'd be happy to help you navigate the market.